Senior Orengo, Council Orengo, it is now 3:05. Yes.
My Lord, I presume that we have 2 hours.
Just for record purposes.
Yes. And my Lord, friends for
I'll
the
say
President.
kindly introduce yourself for purpose
Yes.
of the record.
I'm so sorry. My name is James Orengo. I appear for the BBI Secretariat and Right Honorable Raila Amolo Odinga.
Yes.
My Lord, we have 2 hours, but as indicated earlier when we met as a group of appellants, the team leading the President's appeal, equally as they did with the Attorney General, gave us 30 minutes. I don't know whether that can be accepted by the court. But that was in relation to the fact that we didn't want to deal with the same issues they were dealing with, and they're not dealing with the issues that we're dealing with. It was for purposes of ensuring that we stick within those 8 hours.
Okay, just take your 2 hours. Let's see what happens thereafter.
Yes. My Lord and my ladies, thank you so much. First, before I go into the submissions, I would want to inform the Honorable Court of the documents we have filed. And all the documents we have filed are in a shade of red. They include the record of appeal, which is in 20 volumes, volume 1 to 20. Number 2, we got a case digest and a bundle of authorities, is volume 1 to 4. We have number 3, written submissions, which are dated 8th of June 2021. Number 4, we have the list of authorities, also dated 8th of June 2021. We have written submissions in reply to the respondents and the amicus dated 27th June 2021. We have a further case digest and list of authorities dated 27th June 2021. And number 7, we have written submissions in response to Miruru Waweru's additional evidence dated 28th June 2021. Number 8 is an affidavit which was earlier referred to by Mr. Dennis Waweru. And finally, we have the Constitution of Kenya Review Acts of 208 and 1997, and the National Accord, and Reconciliation Act 208. Those are the documents we have filed. For purposes of presentation of appeal, we have 2 broad categories, and in each category, my lords and my ladies are going to be addressed by 4 from our team. In category 1 of the issues that we are dealing with, it will involve a bit of history, because the court dealt with some element of history and context. And issue number 2 will be the court's approach to interpretation. We think it's an important issue to address the court on. And most importantly is the issue of the basic structure doctrine, which is related to eternity clauses and the unamendability doctrine. These themes are going to be addressed by me and Mr. Paul Mwangi. The second theme, or a list of themes, will deal with the constitution amendment process by popular initiative, public participation in a constitutional amendment process, and the standard of public participation in a constitutional amendment, Then the commentaries on the Justice and Legal Affairs Committee report, a role of the court in a constitutional amendment process, and finally, justiciability, ripeness, mootness of the petitions as presented before the Superior Court. All these issues together will be addressed by my learned friend, Senior Counsel Otiende Amolo, and Senior Counsel Lucy Kambuni. Now, Your Lordships and Your Ladyship, I wanted to start these submissions as a first principle to deal with the Constitution itself, particularly Article 1, Sub-Article 1, because I think this forms the framework under which this Constitution can be interpreted correctly. And a lot of the other issues that are dealt with, including basic structure and the sovereignty of the people, if they are read together with Article 1, Sub-Article 1 of the Constitution, then it will make some sense. And I want to submit that even the question that was asked by Justice Tuyot about the people, a reading of section Article 1, Sub-Article 1, together with the preamble, answer that question. Now, in saying this, I want to ask this question. Does the Constitution of Kenya create a situation where the people as sovereign exist outside the Constitution or within the Constitution? That is a very important question for your Lordships to address. Because the manner in which the court dealt with the question of basic structure is as if the people, being sovereign, can exist outside the Constitution. They can operate outside the Constitution. And the answer to this question is that they cannot, under this Constitution. Even with the sovereign power, the sovereign will, the people have to obey and comply with the Constitution. And this is clear from Article 1, Sub-Article 1. And if you allow me, my Lord and your Ladyship, it says, all sovereign power belongs to the people of Kenya and shall be exercised only, I emphasize the word only, in accordance with this Constitution. So as the people exercise sovereign power, they have to do it within the Constitution. And I think that the trial court got this wrong from the very beginning. They were imagining a world where the people existed outside the Constitution. And this is very clear even in the preamble, because the people in enacting and adopting the Constitution were adopting for themselves, it says in the Constitution. We adopt it to ourselves and for future generations. And the second point to make on this question is that this Constitution, Article 2, Sub-Article 1, this Constitution is the supreme law of the Republic and binds all persons. It binds all persons. And no person within may claim or exercise state authority as authorized under this Constitution. What am I trying to say, your Lordships? And if ever the court thought about context and about what the Constitution making was all about, it was to provide a lasting peace and a form of governance that would create a truly democratic and just society that abided by the rule of law. You cannot, by constitutional contrivance, elevate national values, and which include the rule of law, and when it comes to the sovereign, the people, you say that because they are sovereign, then they can have an existence outside the Constitution. That, under this Constitution, it is not possible. My Lord, if that were true, because all power is donated by the sovereign, including judicial authority, my Lord, your powers are donated, judicial authority. And this is not a thing that has never happened in this country before. When Jiku can come to this court and say, now you have to surrender judicial authority to me, and you judges must retire because we are sovereign. My Lord, that is not how a democratic society, which is based on the values spelled out in Article 10, can operate. And therefore, having said this, my Lord, there was my ladies, there was a French philosopher and historian and writer whom I like quoting all the time, Voltaire. Voltaire once said, and he was a deist, he believes in deism, which means he believed in God, the existence of God. He said, if God did not exist, it would be necessary to create one. The court, the trial court, because they were so anxious about applicability of the basic structure doctrine, they had to create it. They had to invent it. Because nowhere does it exist in the Constitution. And we can go through how they did that. And they had to go to a wonderland. My Lord, sometimes you see a movie or a novel which is so compelling, but at the beginning you're warned that the events you're about to see are not true. Or the characters referred to are not real. My Lord, this court should have warned that as we deal with this matter, it does not exist in the Constitution, which eventually they did say, that there are no explicit provision covering the issue of basic structure. And I want to say the question of basic structure, really in every society, even a dictatorship, there's a basic structure. Even in a theocracy, there's a basic structure. If you go to the Roman Curia, the Papal Curia, there's a basic structure there which has gone for centuries. Even in a military dictatorship, there's a basic structure. In the United States, before the Emancipation Declaration, slavery was part of the structure of American society until the emancipation. Before the amendment of Section 2A, if you read Section 2A in the retired Constitution, the one-party system was part of the basic structure. It said so. The question is amendability. The question is amendability, which my learned friend Paul Mwangi is going to talk about. In dealing with this question of basic structure, in order to answer that question, which the judges never did it in any part of the judgment, they decided, and that is in page. My Lord, in answering that question, it's very interesting. If you look from page 141, paragraph 393, they're dealing with the question of the basic structure, doctrine, and its application to Kenya. And they come to the conclusion, if I come to the right page, in order to deal with this question, what guides the court to deal with this question of basic structure? Is it the Constitution? The answer is page 41, paragraph 41, I'm so sorry, in page 148. We think, I quote, we think that the appropriate response to this question can only be given after one fully understands the history of the making of the Constitution of Kenya 2010. That history provides the appropriate context for answering the transcendental question posed. So, my Lord, they put the Constitution aside and demonstrate that when they're dealing with other questions in relation to the Constitution, they begin with the text. They set out the text. In fact, in order to make this point with some finality, my lords, if you look at, and this is in several pages where they deal with several questions to deal with the Constitution, they set out the text in the Constitution that they've got to deal with. My Lord, if you look at page 256, and the subsequent paragraphs where they're dealing with Article 89, they begin by looking at what that article says before they begin to apply history, context, and other non-legal considerations which they set out. My Lord, again, if I go to page 182, you'd find they are dealing with the subject of the constitutional remit of popular initiative. Again, they said...
Mr. Orengo, please help us here. If you could refer to the paragraphs in the judgment as opposed to pages.
Okay, I'll refer to the paragraph. I'll stand guided. From paragraph 475, my lords, you find out they set out the Article 255 to 257 before they begin to examine it. My Lord, on page, paragraph 532, they set out the provisions of Article 143. My Lord, you see what they say at paragraph 533, having set out what is in Article 143. And they begin by saying a plain reading in paragraph 533.
Yes, Counsel.
Yes.
Please proceed.
Okay. My Lord, again, you can see from paragraph 560, they talk about, in relation to the Kenya Amendment, Constitution of Kenya Amendment Bill, when they are dealing with several provisions, they talk about, they say a reading of the Constitution is clear, that only Parliament can legislate. That is in paragraph 560. My Lord, again, in paragraphs 581 when they're dealing with the issues in relation to the president, and in paragraph, that one I talked about earlier, when they're dealing with the issues of amendment of the Constitution, my Lord, you find clearly that the starting point when they're dealing with those other provisions of the Constitution is the constitutional text itself. They do not go to the history or context. They start with the text. And your lordships, we want to persuade this court that you cannot interpret the Constitution without referring to it. The starting point is the text. The second stop is a holistic reading of the Constitution. So you're like my learned friend, Mr. Karori, was saying, you read all the provisions of the Constitution together. If that is not clear, then, my Lord, you can go to context, which context is also important. But, my Lord, the point I'm trying to make is that you cannot begin to interpret the Constitution. And when it comes to interpretation, the Constitution constantly talking about in order to construe this Constitution. So you must go to the text and begin with a lexical analysis of what the Constitution is saying. So, my Lord, what then happened is that because there were no provisions in the Constitution demonstrating that in any form, shape, or form, the basic structure doctrine applied in Kenya, they had to go to history and they had to go to context. And in looking at that history and context, it was skewed because they were very enthusiastic talking about the context between 1963 and 2010 and came up with the conclusion that the Constitution was amended so many times. There was hyper amendability of the Constitution during that period. But what about the important context of the last 10 years? If they were doing an objective analysis of the context of this Constitution vis-a-vis the retired Constitution, what has happened in the last 10 years is also critical. But that was conveniently left out because they were not going to prove that indeed this Constitution 2010 has put a very rigorous process for amendment. In fact, my lords, I want to submit that in order to amend this Constitution, you have more, it's so rigid that unless you can be able to attain all the nearly 10 goalposts, 10 hurdles that you have to go through under 257, you cannot not be able to successfully amend the current Constitution through a popular initiative. And, my Lord, Justice Kiage was talking about the general suggestion. And I would invite the court to look at the Elections Act, which has nothing to do with the referendum. There are referendum provisions, but it has nothing to do with the referendum we are talking about. The Elections Act gives the president actually the power to come out with an issue to be taken to the people and a referendum held.
Do you have a section?
Yeah, I think it's section 49 of the Elections Act. It has nothing to do with the amendment of the Constitution. But the president can, like in the Commissions of Inquiry Act, take the matter to the people. The only difference is that once the president has identified what he wants to be taken to the people, the IEBC is required to formulate a question or questions in contradistinction to a draft bill under 257. So that is all that I want to say on the question of the basic structure, and my learned friend Paul Mange is going to address you on other issues that relate to basic structure. But all that I wanted to say is that the learned judges contrived a result. They were being ideological, let me put it that way. Like in the Kasef Nada case from India, even amongst the judges, you find, in India by their constitution, it is a socialist state. India is a socialist state by constitution. You would find one judge who is a liberal. In terms of basic structure, they emphasize the Bill of Rights. You find a judge who is more open to socialist themes, would say that issues of welfare form the basic structure. So that even the 7 judges in that court were not agreed on what constitutes basic structure. And in that regard, even these judges in the trial court, other than a repetition of the sections that are contained in Article 255, if you go to the judgment, my lord, you'd find that most of the matters that are amendable through referendum under Article 255 were considered by the judges as forming part of the basic structure. And if you look at 255, 1A, even the supremacy of the Constitution, the provisions in relation to the supremacy of the Constitution, is amendable.
So Senior Counsel, to get you right on what you're saying and your statement earlier that every society has a basic structure, the question is the amendability.
Amendability.
So do I get you to say that every article in the Constitution is amendable as long as it is done constitutionally?
You got it right, my lord.
That is your...
That's our submission.
That's your submission?
Yes.
Okay.
And in these constitutions, there's some kind of hierarchy. The first 10 articles of the Constitution are really foundational. They talk about what type of country we aspire to be. They are really found in those first 10 articles. And my lord, if you go under Article 255, sub-Article 1, up to I, including the national values and principles, the Constitution says it's amendable, so long as you follow the procedure. Now, my lord, we want to invite the court. The entire record of the constitution-making process is in the archives in the courts here. 26,000 pages in terms of documents, 16,000 pages of Hansard. I want to confirm to you, and I'm going to refer to the record that we have, the question of having a basic structure never arose during the constitution-making process. Never. And if it arose, that evidence should have been placed before you. In fact, what arose, which is somewhere near what one can call the basic structure, is found in the Committee of Experts report, which is found from page volume 4 of our record, from page 1501. I think it runs to nearly page 1645. My Lord, at page 1539, the only issue that arose that went before the Committee of Experts in terms of having a non-derogable provisions in the Constitution related to the question of torture. It's there in the report. It's there. I would want to be informed if in any of the reports they answered, and the Committee of Experts had many reports, harmonized report, and so on. If in any one of those reports there is any indication that there was an intention to create some provisions which were eternal clauses or which were not amendable, my Lord, you'll find none. Instead, the Committee of Experts identified only 3 issues which were contentious. And those are found in page 1548. And if specifically I can refer to those contentious issues, page 148, chapter 6 of the report of the Committee of Experts. The first one was system of government, the nature of the executive and legislature, devolution, and transitional clauses. That's all that brought contention. And in addressing those 4 issues, it never went to the people. It went to Parliamentary Select Committee. That is borne out by the documents that we have before you and in this report. It went to the Parliamentary Select Committee in Nabasha, the Committee of Experts, and Parliament itself, where there were attempts to amend the draft constitution, the bill that went before Parliament, and none of it succeeded. And this addresses another important point, because we are being told all the time that this document, Constitution 2010, is a product by Wanjiku. My Lord, this Constitution of Kenya 2010 was a political settlement. It was a political settlement. The referendum came only after the political players and institutions of governance, Parliamentary Select Committee, and the Committee of Experts had agreed on a final version in which the Attorney General played a significant role. That is the document that went to the people. Because the document that was in Bomas was not agreed upon. And the Constitutional Review Commission Act of 2008, which reignited the constitution-making process, instead of going to the people, it took all these issues to the organs of constitution-making, which included the Committee of Experts, Parliament, and the referendum. So we must disabuse the people who are trying to say that this constitution was necessarily a product directly from the people of Kenya. It was a political settlement. And I want somebody to show me any evidence to the contrary. That Parliament did not play a role, Committee of Experts didn't play a role. In fact, the Committee of Experts itself, which is an organ of constitution making, the appointment did not just involve Kenyans. It involved non-Kenyans. In fact, the road and the path toward constitution making, which required of the president of the day to constitute several committees, including the Waki Committee, the Cridler Committee, all of them had foreign participation.
If I may ask, Senior, now why you are saying it did not come from Wanjiku, it came from experts, all those that you have mentioned. Then why, what is the criteria? Why did you go back and surrender the power to the people?
Yes, because, and that is a good question, Your Ladyship. In the constitution making process, after the negotiations, it was determined that the people had a role to play. And the theme is there, Article 10, the values and principles, the national values and principles, people participation, in parliament, people participation, and in the referendum. So that all through the process of governance, the concept and mechanism of public participation is important. But I think one of the things that Kenya was trying to do, looking at our neighborhood, that we should never use insurrection or revolution as a way of bringing about constitutional change or bringing an amendment to the Constitution. Because Kenyans have been to the streets. Kenyans have suffered violence. My Lord, this judgment refers to agenda number 4, how to address long-standing issues in Kenya, which included some of these things I'm talking about. So, my Lord, I may take too much time, but it is really painful at the end. And let me say this, that every opportunity that the people may have to amend the Constitution as sovereign, that to make it even one step, the people cannot make. Whereas when Parliament had parliamentary authority and sovereignty, they could do it anytime. But for the people of Kenya, you have to ask yourself many questions. Am I a promoter? Certainly that word is so significant. And we should ask ourselves, why is the word promoter used? And why is there any prohibition in the Constitution? Who is stopped from being a promoter? It's like saying you judges should not vote or be seen voting, because that's an exercise of political rights. So, my Lord, I really believe that in democracies where a referendum is a way of allowing people to participate, to make choices, including amending the Constitution, decisions made by the judiciary should favor the exercise of political rights by the people, not the other way around. And finally, my Lord, I just want to say this in conclusion. If you look at the orders that the court made, and we agreed by all of them, I want your lordships to tell me if this is not lawmaking. Paragraph 784 in the judgment, paragraph 784. If this is not a usurpation of sovereign power and usurpation of legislative authority, the first declaration, a declaration hereby issues that the basic structure, doctrine, is applicable in Kenya. That is like Hammurabi the lawgiver. The court has pronounced. That is law. That is lawmaking. B, that the basic structure doctrine limits the amendment power set out in Articles 255, 257 of the Constitution. That is the court saying that when it comes to basic structure, forget about 255. Forget about the rights you're giving in 255. C, that the basic structure of the Constitution and eternity clauses can only be amended through the primary constituent power. Where is that primary constituent power located in our constitutional structure? Other than the academic analysis that the judges have done, and I am saying that there is no such constituent, primary constituent power, because the people themselves, they have said that they'll exercise their authority or sovereignty through the Constitution, which means they respect the organs of the Constitution. And, my Lord, one could go to some of the lawmaking roles that this court took. And I see so many times in the United States of America, when a matter arises, even the Supreme Court, they say, go to the Congress. Go to the Congress. If these limitations are not respected by the court, how would Parliament respect those limitations? And I pray that we live by the true word and spirit of the Constitution, and not begin to put ourselves in a situation where, if I ask some of the very senior lawyers here who have practiced with a long time, and they could have better judgment than people out there, could you tell me, why do you find the eternity clauses in the Constitution of Kenya? We have to come back to you to tell us. And the court says that you have to do it on a case-to-case basis, something like an eternity clause, or basic structure, which is an amendable. That cannot be a matter of intendment. It cannot be a matter of contemplation. It must be in a written constitution. That is the value of a written constitution. So that the constitution in its application and enforcement is predictable, is certain. So I do pray that you allow this appeal and sit down to my little friend, Mr. Paul.
Yes. Senior, I'm just wondering, this, the basic structure doctrine and the so-called eternity clauses. I think some scholars think that the term is a bad term, eternity clauses, but I think they agree on the meaning. My question is, how long has it been in the courts? I mean, other than perhaps this may be the second time it's being, perhaps third time. It may have been mentioned in passing in
Yes.
Joya.
Yes.
But the Indian case was decided almost 50 years ago.
Yes.
And if you trace it, that thought has been exported to almost every region of the world. So question is, you think would you say that the Kenyan, this particular decision is really an outrage of sorts, creating something totally new that has never been seen before?
I think it's good judicial literature, very compelling. But in terms of the constitution that we have, it stands on no pillars. My Lord, I also wanted to say, in conclusion, because you have mentioned that this basic structure may be applied universally, I think really it is not. And if you look where it has been applied in the Asian subcontinent, even looking at the countries themselves, other than India, Pakistan.
Pakistan rejected it, actually.
Yeah, eventually. Or Bangladesh. Is that the league where we are? And historically, we can understand the meaning, why they would want quickly to jump on an issue like this. In Pakistan, where presidents are assassinated and killed, I shiver that we go that direction after so many wars in this country to have a definitive document. And because Justice Kiagi has asked me this, I was going to say it at the beginning, totally unrelated to what you have said. I am a member of FIDA, an honorary member, and I've argued cases for them. So I'll say this with a lot of respect. There's the court's rendition of what they say is history. A lot of times they say, you know, really, what you make of recorded history is not really by the maker or the participants, it's by those who write it. My Lord, I would invite you in the Bible. There's a lady called Jezebel. If you read her story according to the Bible, she was a vile, satanic woman. But if you read other accounts of Jezebel, they are very, very good accounts of a strong lady, believed in the religion in Phoenicia, because she was married to an Israeli, a Jew, Ahab. And asked the court also to read about Marie Antoinette. Her story is terrible. But if you read the correspondence between her mother and between the ambassador and her mother, Emperor Theresia, you'll get a completely different picture. So these judges, they gave us a story that if you don't try to go into the real story, you'd think that politicians are evil. They never really had anything to do with this. But the record will bear out that at every stage in constitution making in Kenya, it's only when we came together, including politicians and presidents, that this process went ahead. And without it, it could not happen.
Right, Senior Counsel, I hope you're watching the clock and remembering that your time is halfway gone.